Understand your rights, exercise your rights, but understand where the time and the place is to do that. This is where you do that. Please, please. Can we have an honest conversation, though? Can we have an honest conversation, though?
Yeah.
Why the hell not just give them your paperwork? You turn that into a big thing that didn't have to be a thing. Seriously.
Wow.
Seriously. I mean, if you would have given him the paperwork, you probably wouldn't even have gotten a speeding ticket. You probably would have gotten a reduced charge on that.
I mean, honestly, I wanted to tell you exactly the whole situation I made right at the time, but basically, like, officer was 3 cars in front of me.
Right.
So I'm trying to figure out how the officer even said, hey, this is the guy who was driving.
Hold on a minute. Your motion is the Polish speaking gentleman. We can't find an interpreter. I mean, literally, we can't find an interpreter that will be here live. So we're probably going to have to adjourn it.
Well, let me see your thought.
And I'm not, I'm not trying to put pressure on you. I don't speak it. Yeah. But hold on. What you're going to do is you're going to tell me you got an argument on the speeding ticket, right? That's fine, but you don't fight that on the street. You come here and fight it here. Seriously, brother, I'm trying to save you grief. How much time has this cost you out of your life? Way too much. Way too much. And seriously, I'm telling you, if you would have given him your documentation, yes, sir, no, sir, just been polite, they probably would not even have written you a speeding ticket, because what they're doing a lot on the road is they're writing you for something that's not even on your record, like a double parking or an impeding traffic. It's a money thing. And even if you don't think you did that, then you come here and we've got like 3 different options. You can take 3 different bites at the apple if you don't think your ticket was a good ticket. But instead, you were facing a frickin' felony. And I got news for you. There are a lot of judges that today would have said, yeah, go downtown, figure it out. And then that's more time out of your life. I'm not saying every cop that stops somebody is 100% right. I'm just saying that the street is not the place to argue that out. Not to mention the fact that, you want to take my job away from me? Right? You got to come in here and let me argue these things. It's smarter, brother. It's just smarter. Yes, sir. Because you know what? You know what you and that cop had in common that day? When you both got up that morning, you expected to go home safe and sound. The news is full of situations exactly like yours that go completely south and somebody doesn't get to go home. Right? Understand your rights, exercise your rights, but understand where the time and the place is to do that. This is where you do that. Please, please. Mr. Wilson, before we get started on this, you owe us all kinds of money on some civil stuff. Are you in a position to make some kind of payment plan? Can you set something up before you leave?
Your Honor, I'm not to object to Bindo in this situation. I understand that questions of identification are often questions of fact, but I don't even believe that the people have met their probable cause burden in this case. That still isn't. Just because you have someone saying, I think it's that person, doesn't automatically create a question of fact. And of course, Your Honor also has the credibility to determine to make, obligated to assess this officer's credibility in that situation, whether he's outright lying or whether it's just a matter of impossibility to make this sort of identification. So I would like to run you through, Your Honor, the factors that have been outlined by Michigan court, most recently the Michigan Supreme Court in a case called People versus Posey. I will put that citation on the record. Posey is People v. Posey 512 Mich 317 2023 decision of the Michigan Supreme Court, which talks about when an in-court identification of a defendant should be admitted into evidence, and it requires a showing of an independent basis for that identification. And I don't think any of the factors that Posey identifies in terms of what would create that sufficient independent basis apply here. So factor number 1, and Posey's factors are borrowed from federal case law from the U.S. Supreme Court, so it's not just Michigan case law we're talking about here. Factor number 1, prior relationship with or knowledge of the defendant. This officer says he's never seen Mr. Wilson before, never seen him subsequently. Factor number 2, the opportunity to observe the offense. We've heard that it was simply the the allegation of seeing him through a window in a moving car and then seeing him through a window as approaching for just a split second before this car peels off. Factor number 3, length of time between the offense and the disputed identification. There's 2 lengths of time I would point out here. One, we have a gap of at least an hour, possibly several more hours between this incident in the field and him looking up this photo back at the precinct. Then we also have the gap of 3+ years between this incident and the only time that we know of Mr. Wilson, of Officer Schurig seeing Mr. Wilson live, which is right here, right now in the courtroom. Then factor number 4, accuracies or discrepancies in the pre-lineup or show-up description and the defendant's actual description. We don't have any pre-lineup or show-up. We do have the viewing of a photo. And I'll just take this opportunity to say that is a 1 photo show-up. That is a type of identification procedure that's highly disfavored in our courts. Decades of research have shown that doing a 6 photo lineup or some sort of live lineup is a far superior procedure than simply showing someone 1 photo. Especially when it's not double blind, you have the person, it's him, he himself is pulling up this photo. He's already thinking, I think this is the person. It's a highly suggestive procedure. Any previous proper identification or failure to identify the defendant, there's no previous identification other than that photo show up. The nature of, this is factor 7, the nature of the alleged offense, the physical and psychological state of the victim or the identifier. In critical situations, perception will become distorted. Any strong emotion, as opposed to mild emotional experiences, will affect not only what and how much we perceive, but also will affect our memory of what occurred. And I'm reading these at length because this is a quote from the Posey case. And this is also a play here where we have officers working in the field, conducting a traffic stop, quickly followed by a high-speed pursuit. He's presumably at a heightened emotional state. And then finally, factor 8, any idiosyncratic or special features of the defendant. We don't have testimony that, this is someone with a gap tooth, with tattoos on his face, wearing an eye patch, nothing about facial hair. We have a black male with braids. He didn't even bother putting in his report. And we do have testimony that the officer is a different race from the defendant, which this court can take judicial notice that cross-racial identifications are even less reliable. So for all these factors, I don't think this case should be bound over. You might say, if he gets on the stand, he's confident that Mr. Wilson is the person. It's a question of fact. But I disagree, because I think this court does have a duty to assess his credibility in the light of these factors, and does have a duty to assess whether the prosecution has met that threshold of probable cause that not only has a crime been committed, but that it's still on Wilson who committed that crime. And I don't believe that's been met. I'm objecting to the plaintiff. Thank you.
Mr. Muhammad.
Judge, we would completely disagree with the defense counsel's position. As this case reflects, is that the officer identified the defendant, indicated that the window was open twice during his interaction with the defendant. He identifies him in court here today as the driver of that vehicle. I believe in court identification is sufficient for probable cause purposes, and I would motion that the court find this case over as charged. Thank you very much.
Thank you, gentlemen. Well, my understanding of the job I have today is the only way I could not bind over if I found Officer Schurig's testimony to be totally incredulous, and I didn't. I think it's an extremely weak ID, but I think probable cause is an extremely weak burden. I am going to bind over. AOI date will be 2 weeks down the road on the 13th at 9 a.m. I will extend the bond as is, and I will ask you fellas to sign the paperwork when I'm done with it. Thank you.
Your Honor, can we address bonds?
Sure. 25,000 personal, I believe.
I was wondering, is the defendant on a Jeep together?
I don't think so.
Your Honor,
I don't see any additional conditions. Do
I
you?
would request that the defendant be placed on a Jeep
Why?
In light of the charge in front of us today, that was already heard, I believe the defendant, light,
Your Honor, there's been no change in conditions. There's as you just noted, an extreme identification of Mr. Wilson as the suspect here. He's not a flight risk because he sits right before you. He's maintained constant contact with myself throughout the pendency of this case. Don't believe there's a failure to appear history on this case. I believe it was late. Wholly inappropriate.
I agree. Bond is as is.
Thank you.
All right. And did we already talk about the money you owe? You're going to stop downstairs? All right. Gentlemen, I just need your signatures and then you're on your way. Good luck downtown.
Thank you.
Did we lose Mr. Smith, Trovius?
Yes, that's
Did you just adjourn that one? Can we get Novak out here?
Yeah.
How come the other interns came in person to see me and you're just Zooming?
Well, I figured after last week I might attend this one virtual.
All right. We'll let you do that.
Sounds good, Judge. Thank you.
You missed all the excitement. You're like at the tail end of the docket now.
I believe, is there a trial though happening?
Don't even ask me. I don't even have any idea what I got. I still got 5 files in front of me, so I'm doing
Okay,
something.
all right. Sounds good.
All right, have fun.
Thank you.
I understand you're ready to take a plea today. There's an offer on the table.
Yes, the offer that,
Attempt.
deal for that exam, what is it called?
So the offer that, as I described to Mr. Blayton,
Guilty.
yes, so, I got it.
Attempt, resist, and obstruct. Right. Which is a misdemeanor, which means you're going to be on the hook to me for probation, but you're not going downtown. You understand that? All right, you understand? You can sit down. I mean, I know it's instinctive, but you're okay. You understand your rights and the options those rights give you today?
Yes.
And you understand we're ready to go for the preliminary exam. You understand what an exam is all about. You want to take that deal?
Yes, knowing that it's not
It's not going to be a felony and I'm not putting you in jail again. Well, I might put you in jail if you just completely don't do what I tell you to do on probation. You understand that? Okay, all right. Okay. Mr. Martin, if you can voir dire to get me the facts I need for June 3, 2025 in the city of Romulus.
Thank you. If I could just confirm one thing on the record.
Sure.
So, Mr. Mohammed. Okay.
Mr. Blanton, you've got another file that you need to be sentenced on today too. You know that misdemeanor charge?
Yes.
I'm just going to give you 30 days in jail, credit for the 30 days you've already spent, and close that file out. Understood? You're okay with doing that without an attorney to represent you? So that file's closed.
I vote for 18 judges. Are there 18 judges?
What's that?
Voting for Romulus right behind you. That old police.
Yeah.
Sorry. Small words might be very good.
No, I got you. The old building, yeah, the old court, they had, those were Wayne County judges. Yeah.
So, Mr. Mohammed and I are just iron.
Yeah.
So, when we had a prior conversation, he framed it as a sentence agreement. So I just want to confirm that with him.
But he knows I don't do sentence agreements. I do sentence recommendations.
So you there's an agreement.
Yeah. Which I probably won't do at all.
Understood.
But I will do this. I am not putting you in jail as part of your sentencing on today's file. Clear? I am going to order you to do certain things for probation. If you just thumb your nose at me and tell me no.
Voluntarily, it's not being a felony.
Yeah.
100% like it's got 12 months and 40 hours community service.
No, stop there. Hold on, Mr. Blanton. Hold on. That's just all stuff that they're recommending to me. I'm going to do what I think is best for Mr. Blanton.
Yeah.
Okay? It might be community service. It might not. It might be you have to go have a mental health evaluation, right? I might decide you have to do mental health treatment. I'm just letting you know I'm promising you that the only way you're going to do any more jail time for me on this file is if you tell me, Judge, I won't do what you tell me to do.
The only thing I said is that I was confirming that it wasn't a felony.
Absolutely. Yeah. As soon as I take this plea, I'm dismissing the felony. All right?
Yes, so although we had a different discussion earlier, Mr. Blanton, this is a sentence recommendation. It's not an agreement with the prosecutor. Judge Oakley will get to decide the terms. Does that include the length?
Absolutely. Absolutely.
I'd like for the see evaluation. I'm making my assessment just based off of my.
Okay. Okay. Let's just talk that out though. If we do that, then either A, I put him on the street, so we got to rely on him showing up for that appointment. Or I leave him where he's at, where he's probably going to sit for at least 4 to 6 months before that evaluation happens. Or we could move forward today and we could actually take steps that could actually get him some frickin' treatment soon.
And for the record, I believe Mr. Blanton is competent to stand trial. I am not requesting a referral for a competency evaluation. I have met with and spoken with Mr. Blanton on at least 3 separate occasions.
And I'm going to use my almost 30 years on the bench to say, from my conversations to Mr. Blanton, I think he's got some issues, but there's no way I would expect the competency exam to do anything but put us right back here 6 months down the road.
I agree.
So with respect, Mr. Mohammed, I'm going to deny your request. Because I think what's best for Mr. Blanton is to move this thing along. You understand, Mr. Blanton, I want to put you on probation bad because I think we can get you some help.
I understand the situation, what's being revealed to me. I'm sorry for the thinking. I'm sorry for thinking that the 12 months and the 40 hours of community service. I was just.
That might be where we end up. That's what they discussed, and that might be where we end up, but it might not be. But I'm promising you.
By saying a little too many details.
Yep, I just want you to understand, I'm not going to accept your plea today thinking I'm putting you in jail. I'm telling you right now, I am not going to sentence you to jail. All right, so let's get back to the plea.
I can lay factual basis unless we want to do any more advice of rights.
I'm convinced you've discussed his rights and his options, and he's told me he understands those rights and options, right?
Just very quickly. Mr. Blanton, so you are knowingly, intelligently, and voluntarily taking a plea today, is that correct? Yes. And you're giving up your rights to hold a preliminary exam where we would challenge the witnesses, is that correct?
Yes. The only thing I add is that the location that I had the incident at is my current residence, and I can't guarantee a tether location.
Right.
That's okay.
All right, so I'm satisfied in terms of advice of rights. I'm going to move to factual basis. Mr. Blanton, I'm going to ask you a few questions to make out the plea to this offense, all right? So I'm going to take you back to June 3rd, 2025. On that day, were you in the location of an address 34170 McBride?
That is what being guilty is. All the details.
You were there, right? Yes. And that's in the city of Romulus in Lee County, Michigan? Yes. And did you have an interaction with police that day?
Yes.
And was there any point during that interaction where the police officers gave you an order that you did not follow?
As far as I'm aware of, pleading guilty is whatever the details are. If there's any stating that is what I did.
But you have to tell me more, Mr. Blanton, so I can accept your plea. Did you refuse to do something the officers told you to do that day?
I refused. I gave them a resist to arrest, and I obstructed justice, and I'm not exactly sure what the charge is.
Okay. My question is, on that day, did the officers tell you to do something and you didn't do it? Did they tell you to leave, or did they tell you to give you them a name, or did you try to resist their handcuffing?
My knowledge of plead guilty is to all the details.
No, that's not the way it works, Mr. Bland. I have to hear from your mouth. Go ahead.
Let me do this. Explain. So later that day, June 3rd, 2025, officers took you to the Romulus Police Department, is that right?
That is correct.
And was there a point where they were trying to sell?
All that information is correct from where I was coming from.
Is that a yes?
And while they were moving you into the cell, was there a point when you were, at any point, threatening or using actual physical force against any of those officers? Yes or no?
Yeah.
Satisfied.
If you are not satisfied, I'd like to ask some questions. That's okay with the board?
If you think you have to.
Sir, on June 3rd, 2025, were you at the location of 34170, right?
Yes. So
Is that located in the city of Romulus, County of Williams?
I'll take note that it is.
And while you were at that location, did you resist Officer Otter by pulling your arms away from Officer Otter?
what is the charge I'm being charged with, sir?
Resisting and obstructing attempt.
Okay, and that was, okay. And was that officer in full uniform?
Yes.
And you recognize that officer as well? Police officer?
I wouldn't be able to.
You knew he was a cop at that time.
Yeah.
Yeah,
Of course, that's fine.
thank you. Did they get, anybody talk to you down there? Okay, so here's what I'd like to do. I'd like to do a pre-sentence today.
Okay.
While he's talking to my probation, just means an interview. My probation officer is going to interview you. While he's being interviewed by probation, I'd like you to have some conversation with the family and see if we can come up with some kind of a plan.
Right.
Okay? Okay?
There's not already a PSI on file, right? Because he was supposed to be sentenced on
I don't think we ever did one.
Okay,
I don't think we ever did one because he was in custody all that time.
right.
Yeah,
Okay.
yeah.
What around this? Sorry for, keep on saying different things that aren't.
You're okay. You're doing all right, Mr. Blanton. Yeah. You're doing fine. You're doing fine. So what we're going to do is we're going to put you back in the holding cell right now until we can put you in an interview room with a probation officer. All right? You're welcome. No, you did not disrespect me, Mr. Blanton. You're fine. You and I got no problem.
And so the case is not closed yet, there will be a future sentencing date.
Yeah.
Okay.
Well,
But
it might be today, but I'm just not that hopeful.
I see. Well,
I'd like to sentence him today, but I want to have a plan in place when we sentence him.
thank you. Oh,
So, Mr. Mays, come on up, son.